Hello everyone. So we are in week 2 of conflict management through mediation course. In this week, we were discussing the various alternative dispute redressal mechanism in depthly and comparing all of them with mediation. So in today's session, we will be discussing on the negotiation. Let us never negotiate out of fear, but let us never fear to negotiate. This has been laid down by John F. Kennedy, wherein negotiation takes place in everyone's life. Usually, what happens is like whenever we go out for marketing, we negotiate the price of the commodity for which we want to buy with the sellers. And everyone is well acquainted with the negotiation. But what actually negotiation means is so it is a dialogue between the parties to get what one wants from the other. It is a primary and a common mean of securing one's acceptation from others. So it is a communication back and forth designed to reach an agreement when two persons have some interest that are shared and others that are opposed. So basically what happens in a negotiation process is to identify the interest or securing one's acceptation from the others, which can be done by means of a communication between both such parties. It may be to and fro. It is a process to address the difference or disagreement between the two or more persons. It involves give and take within the context of particular relationships. The Pepperdine University of USA defines negotiation as a communication process used to put deals together or resolve conflict. It is a voluntary, non-binding process in which the parties control the outcome as well as the procedure by which they will make an agreement. Because most parties place very few limitations on the negotiation process, it allows for a wide range of possible solutions, maximizing the possibility of joint gains. So with this definition, we can put forth that the silent features of negotiation. So basically, the negotiation is non-adversarial method. It is because there is no adjudication process. There is no one here to make the decisions because it is a party-centric communication that takes place between the two parties. It is a collaborative method wherein parties themselves come together and discuss among themselves to identify the interest and reach out the each other's expectations. It's an informal and a flexible method because there is no procedure at all to follow in a negotiation. So that is where it is informal. It is very flexible because at any time it is at a discretion of the parties. The parties can meet together at any time, any place, and they can discuss among themselves or negotiate among themselves with respect to their expectations. It involves only parties to the disputes and no intervention of any third party, whereas in case of mediation, conciliation, arbitration, so there are certain third neutral party who are assisting the parties to resolve their dispute, like by means of mediator, conciliator, arbitrator, whereas in case of negotiation, there is no person required to negotiate. It is a party-centric process. It is totally a party-centric process. Even this is unlike conciliation, unlike lok adalat, unlike mediation. It is also a voluntary process wherein the parties can at any time walk out of the negotiation process if they are not acceptable. It is a non-binding process and it involves bargaining and give and take policies. So these are some of the basic features of negotiation. Coming to the merits of, based on the silent features, we can identify that it is a party-centric process, it requires less expensive. There is no requirement of any cost at all to negotiate. It also less time consuming. because party can negotiate among themselves, they can reach to the settlement, they can come to the place where they require, they can even discuss on calls, whatever it may be. So this is how it is time consuming, less time consuming. It addresses the needs and interest of the parties. Basically, whenever the negotiation it takes place on the basis of the interest. So say for example, you go for a cloth shop and you like a cloth, and the price of the cloth is, like, say for example, 200 rupees, and you want to buy it for 180 or 190 rupees, and you go and request that seller, or you negotiate with the seller to give it to 180, or when you start with the negotiation process, you start it from the downtown, like you ask it for 150, and then the seller will come in the middle, like around 180, and once like that you settle out, you negotiate, and you purchase that product. So basically you are concentrating only on the interest of yours. So that is how it is based on the need and interest of the parties, and it is a party centric and party control, because you are the one who are making the or proposing your interest, and the other party is also looking out for his interest. So it is more participative between both the parties. There is a lot of flexibility with respect to time, place, procedure, and even there is no risk involved at all. As in case of courts, as in case of arbitration, so there is a risk involved in that, because in case of courts, if there is a decision which comes from the court, it may go against you. But whereas in case of negotiation, in case of mediation, in case of conciliation, there is no such risk involved. And there is a creative remedies possible with the negotiation process. You can come up with more remedies which are possible, or you can come up with more options that you have in mind, or you can propose such options wherein the party may accept or reject. Even it is a confidential, because unlike mediation, unlike conciliation, how whatever that has been discussed during the procedures of conciliation, mediation, even the negotiation process cannot be held as an evidence in a court of law. So there is a high rate of compliance with the outcome, because it is being a party centric in nature, wherein the party themselves negotiate and accept it for the interest which they have in mind. So that is where there is a high rate of compliance with the outcome of the negotiation process. So it is always win-win situation for both the parties. So there are certain demerits of negotiation, because there is a lack of seriousness among parties, because it is being an informal process, a non-binding process. So sometimes the parties may not take that much serious as in case of courts, mediation, conciliation, or arbitration, because it has judicially recognition for that. But whereas being negotiation, it's not recognized, and being informal in nature, the parties are less serious towards the process of negotiation. The scope for withdrawal of the parties at any stage of the process, because it's a non-binding process, and anytime the parties can walk out of the negotiation process. It could be used as a tactics to delay the litigation, and even because until and unless you go on discussing, there will be a drag tactics can be imposed to delay the litigation. It could be used to know the stand and strategies of other party to the dispute. Like before moving on to the party, like the party may negotiate and understand the stance and strategies what the other party has in his mind, and he can even file a litigation against the negotiator party, that is the opposite party. So the negotiation process, so this is a challenge of negotiation process, that what I can say. So there is no legal framework to govern the negotiation process. So there is a lack of bargaining and communication skill that may take place, because in certain circumstances, the opposite party may be at a dominance position, or he may influence and coercion may operate on the other party who is illiterate or who is having less bargaining power, or he may not have communication skills to bargain. So that may also hinders the process of negotiation. So there is no uniform procedure, and sometimes this negotiation process is not suitable for all the legal disputes. So these are some of the demerits of negotiation. So basically, how the negotiation process takes place. Let's discuss on the process. So basically, when we start negotiation, the one party requests the other party. When both the parties agree for negotiation, the parties prepare and plan the agenda by means of prioritizing the parties' goals. They prioritize their goals, they prioritize their interest on which they want to negotiate, and they come out for the negotiation proceedings. So the proceedings can be held at any place, they may sit at any place at their own wish and will, and the negotiation process will commence with the opening statement of both the parties, and thereafter it will lead to the bargaining, coming to the specific agendas, prioritizing the interest. They bargain. The bargaining may be of two types. It may be competitive bargaining or it may be cooperative bargaining. And by means of this competitive bargaining or cooperative bargaining, they reach at a agreement by means of formalizing the agreement. Once the agreement is formalized, it will be drafted and developing the procedure of implementation. Even in case of negotiation, because it is being a party centric, most of the parties will also develop the implementation procedure. How this agreement will be implemented, all the procedure will be laid down in that agreement, and lastly all the parties sign to that agreement. So this is how the closure and implementation of negotiation process take place. There is an important aspect that we will discuss in the next slides. That is, for a negotiation process, the basic concept is like the bargaining. The bargain is one of the important factor to resolve the dispute or to reach at an agreement, prioritizing our interest. So it may be two types that what I discussed. That is a competitive bargaining and a cooperative bargaining. So that we call it as a styles of negotiation as well. In case of cooperative bargaining, a negotiator who adopting a cooperative styles are mutually respectable in their choice of language, the place, listening, and non-verbal interaction. Basically, when in a cooperative style of negotiation, the emotions, the face on an emotion is like it will be a smiley face because it's a cooperative in nature. Whereas in case of competitive style, the emotions on the face will be arrogant. Like it may be coercive, it may be tense on the interpersonal dynamics. Sometimes the language may be aggressive, and this is all that plays a very vital role in reaching out to an amicable agreement. So, cooperative style prefer positive interaction which promotes an understanding and a culture of working together. Like the parties have a mutual understanding in cooperative style of negotiation, whereas in case of competition style, it won't be, because it is creating tension, it is creating distrusts, and even sometimes it results in deadlock, being in a competitive nature because using of aggressive language, using of coercive tactics in a tense mode. So what happens is like the aggression will take place, and being a voluntary in nature, sometimes the party may walk out of the negotiation process, and there is a lot of chances of a deadlock in a competitive style of approach when compared to cooperative style of negotiation. In cooperative style of negotiation, there will be some common interest exist between the parties and attempt to understand others' interest as well. Whereas in case of competitive style, the parties keep on stretching the facts, sticking onto the position and not being tight-lipped, try to maximize their own returns and manipulate the opponents. This take place in the competitive style of negotiation, and this will be certain hindrance to the negotiation. So cooperative style is one of the most important style, and that can be used for a fruitful negotiation process. So basically these two styles are adopted for bargaining. So there are various approaches of negotiation. Sometimes the parties keep on competing because there are various examples, like, so the competitive nature, like they have some egoness, like I need to win, I cannot lose at all. So these types of circumstances, we call it as a competitive negotiation. Avoiding. So avoiding is a nature, like he has suffered me a lot, I will also suffer him a lot. He had broken my teeth, I will also break his teeth. So these types of circumstances when occurs, that type of negotiation approach, we call it as avoiding negotiation. So compromising negotiation. In case of compromising negotiation, this is like this plays on a scale of like sometimes we lose, sometimes we win. So these are the circumstances we may arise, because compromising is like compromising our interest. Like in case the one which I explained earlier, say for example, like you like the example of cloth, like you wanted to buy it for 180, but the thing is like like the seller is not agreeing to come it to 180, and you compromise it for 190 rupees and you buy. Here in certain circumstances you win, that you won, that he at least decreased 10 rupees, but you also lose that you also gave him an additional 10 rupees of amount for a seller. So this is where the compromise negotiation take place. Whereas accommodating style, coming to the accommodating style, see, I lose, you win. So sometimes this style, like if I lose, it's okay, but I want that. Say for in the same example, if the seller doesn't agree to give it 2 rupees or to reduce any amount, but because of your interest in that cloth, you purchase it for 200 rupees. Although your interest to purchase that product was for 180 rupees, you give it 180 or you give it or you purchase it for 200 rupees. So this style of negotiation, we call it as accommodating style of negotiation. Whereas in case of collaborating style of negotiation, I win, you win. So this is also a great style of negotiation. So I will just take you an example of an orange. So there were two brothers. This example is already been discussed. Wherein, so there were two brothers and there was only one orange at a home. Younger brother wanted the pulp of the orange, whereas the elder brother want the skin of the orange. And so they both were fighting. And when negotiating, they came with a differentiation that, see, I only need the skin. If you want pulp, you can take out with that. So this is how there is a win-win situation between both the brothers. Like one wanted the skin, one took the skin, the other wanted the pulp, the other took the pulp. So this is a win-win for both of the things. In case of compromising thing, like they could have cut it down in a half, and that could have been a compromising style of negotiation, because both are getting something and both are losing something. So this is how a best example for compromising style, like cutting half the orange and dividing among both the brothers. So wherein, so one will be losing something, so like the half of the orange pulp, and some will be losing the half of the orange skin, and some will be gaining. So this is how the negotiation should take place. Like sometimes it may be compromising, sometimes it may be accommodating, sometimes it may be collaborating or competing. In some situations you have to be competitive in nature as well, and even avoiding. So these are the approaches of negotiations. Now we have understood the basic concept of negotiations, We have also understood the approaches of negotiations, the style of negotiation. Now let us understand this negotiation with what are the difference between a mediation and negotiation, or what are the similarities between mediation and negotiation. See, mediation as well as negotiation both are voluntary in nature, because at any time the parties may walk out. The mediation is a method to resolve the dispute in which an independent third party assists to resolve the conflict between the parties, whereas in negotiation there is no intervention of the party at all. There is no intervention of any third party required, because it is a party centric, wherein both parties themselves can negotiate among themselves and resolve the dispute or reach at an agreement based on the interest which they have. So negotiation is a method of dispute resolution in which the parties settle their conflict and reach an agreement through discussion. A mediator meets both the parties jointly and separately to talk about the issues. And in case of negotiation process, negotiation being a party centric, the party themselves can meet each other at any time, anywhere, and discuss the conflict, interests, rights, and come to an mutual agreement. Mediation, the parties themselves or by their representative represent their interest or through mediator, whereas in case of negotiation, the parties themselves may negotiate or their representatives may also represent their interest. Like in both the cases, like in case of mediation as well as negotiation, the lawyers of the parties can also involve in reaching out to an agreement, wherein the representatives like the lawyers or any agents, they may appear in the mediation process or a negotiation process. They discuss, they put forth they represent the party's interest or rights and reach out to an amicable agreement. So the parties, in case of mediation, the parties themselves reach an agreement with support of mediator, whereas in case of negotiation, the parties themselves reach an agreement. Another important thing that I would like to discuss, in case of mediation, the process of mediation that can take place in three circumstances, that is pre-litigation, post-litigation, and court-annexed mediation, whereas in case of negotiation, it is just a pre-litigation, because sometimes it may be post-litigation as well, but the negotiation can never be a court annexed, because court never refers the matter for negotiation. So this is all about the mediation and a negotiation, and the difference between mediation and negotiation, the similarities between negotiation and mediation. With this, I conclude. Thank you.